just give me one or two things that you think the DA's office can be doing that it either isn't doing or should be doing or is working on doing to help fight the influx of illegal drugs into the county. First.
Okay, you're definitely correct. The influx of, I believe heroin and methamphetamine are the scourge of the community. They're highly addictive. They create one-man crime waves. And the people who are dealing those drugs need to be given stiff sentences, and they need to be given plea bargains that are not bottom of the standard range. They need to be pled to stiffer sentences, and if need be, taken to court. A lot of the heroin and methamphetamine arrests are on controlled by busts. There tend to be your stronger cases where you have confidential informants who are wired. Those people need to be nailed to the wall. The people who are bringing bath salts, when I say methamphetamines, I also mean bath salts. They're similar. Those people need to be nailed to the wall. And you know, the police are doing a pretty good job arresting people, but we have to see it through down in Sunbury and make sure that selling heroin or methamphetamines in Northumberland County Northumberland County should be a place to be feared to do stuff like that in.
Do I go now? Yep. Okay. The district attorney's office has been participating in the drug take-back program. We just did a day in September in which we collected prescription drugs, and I think this is one area that really needs to be addressed. In the paper today, and I'm not sure which paper it was, they talked about a string of burglaries that had occurred in the coal region. Those burglaries are drug burglaries. Those are people breaking into homes to take prescription drugs. So one of the things that we've been working on is eliminating prescription drugs that are no longer needed. That's why we have the take-back boxes. Now, not all the police departments participate in that, but we have been encouraging more and more departments to get that, and I know that there is a move on here in the 108th to get more boxes at police departments. I'd also say we have increased the activity of the Northumberland Montour Drug Task Force. The Drug Task Force was somewhat dormant for a little bit. We've brought that back up into action, and we've been addressing additional crimes, not only just the drug busts themselves, but as well as the property crimes that arise out of that. Was it under?
Right at.
Oh, good. Timed that right.
The next question is actually a public comment question, and it's going to be asked by Justin Strauss.
Would either candidate, meaning you two, use their position as district attorney as a stepping stone for higher office, such as judge?
I go first? Okay. I do not have any intentions to run for judge. I think if I had planned to do that, I would have done it this time when there were 2 seats open. My first love is prosecuting crimes, and I think my career has shown that. I've stayed as a prosecutor because that's where my dedication is, and I don't have any intention of running. I think it's going to be a while before there would be an opening in any event. We just had 2 new elections. But I don't have any intention to seek higher office.
Absolutely not. District attorney, in my opinion, is better than judge. I clerked for a judge. A judge is it's a lot of power, but the district attorney is action. You're constantly thinking. You're constantly involved with the community. The burden is on you to build your case and to attack and to go out after people. When I worked there, I couldn't wait to get up in the morning. I thought that was one of the neatest jobs ever. I really loved the job. So short answer is in no way, shape, or form would I use that as a stepping stone for not only judge, but for any other office. Thank you.
Okay. All right, the next question will be asked by Andy Einsman of the Shamokin News-Eye.
I guess I'll sort of direct this toward you, Tony, on the issue of plea deals for drug defendants. Ann has said in the past, has told our paper that sometimes you've got to let one defendant walk in the effort to get a bigger fish in the pond, if you will. And a lot of times DA's office, again, what she said, isn't able to, the public doesn't necessarily know that, so it just seems like they let someone walk. With that in mind, what would you do differently, or do you think you would be faced, with similar circumstances and would have to allow that to happen, or do you understand the process differently and would try to do it differently?
Sure. No, I understand the process. And when you have a confidential informant who's going to give you a bigger fish, then yes, you have to let him walk, and you have to take that, in the face of the public. And she's correct, and you're correct. The public does not know that all the time. But for people who aren't doing that, I think the plea agreement should start at the middle of the standard range and go from there, not usually at the bottom of the standard range or the easy, the mandatory minimum or intermediate punishment. For someone, dealing drugs, that should start, that should have a higher bar.
And in response to that, I guess you kind of set forth what my position is. I would just tell you that I kind of disagree with that characterization. When plea agreements are made on any case, whether it's a drug case or a theft case, a bad check, retail theft, the Commonwealth needs to take into account many facts. Sometimes it's the strength of the case. Sometimes it is whether or not an individual has been cooperative with the police, or whether or not the police have done the best job, and that not through their fault, but through the facts that they come upon. So in drug cases, we don't make the decision solely upon whether or not we have a confidential informant. There's a lot of other factors that go into it, and which we don't share with the public. Thank you.
Yes.
Yes, and Mr. Heintzelman, I just answered your question about the confidential informant. There are other factors in the case. Just like she said, strength of a case. But when you get into felonies and higher level felonies, the district attorney and the police should be working closely together to make sure that when they file the charges that it is a strong case that the DA is willing to take to trial.
I'm okay, that's fine.
Next question is going to be a public question asked again by Justin Shaw.
How are you qualified to serve at DA with no criminal background? I'm assuming it's directed at Tony, but you can both answer.
If somebody's saying you don't have any experience.
Well, I would just say that I do believe that experience is important. If anybody doesn't realize that by now, I don't know where you've been living. Certainly not in Northumberland County. I guess I'll just, I thought the questions were supposed to be for both of us, but okay.
I thought that too. But since it was asked, I have courtroom experience. The laws of evidence are the same. The substantive laws are a little different. I was an assistant district attorney for a few months. I am admitted to the Pennsylvania bar. I've done criminal defense. I am qualified to handle a criminal case. I've had hundreds of cases in front of Judge Saylor, mostly for children and youth, but unfortunately, not unfortunately, for my record, they're all closed because they're dealing with minors. The records are sealed. I can't discuss them other than give the case number and the initials. And I did have many of those. So I have a lot of courtroom experience. We would have, just guessing on average, at least 10 hearings 3 times a month. So I was in court a lot. So that's how I would answer that question. I do have courtroom experience. I do have several months of criminal law experience.
And I guess I would just say that experience does matter. Experience is the thing that allows us to prosecute cases, to be able to judge facts, make determinations, make decisions on whether or not a case should go to trial or not, how we believe a jury will take things. And the rules of evidence, the rules of criminal procedure are different than rules of civil procedure or rules of orphans court, which is estates, that sort of thing. So I think that there is a big difference, and I think that experience in the criminal realm is important.
And I could assure you I fully understand the rules of criminal procedure.
The next question is from the daily item, Justin Straw.
Excuse me, would you have the person who's asking the question stand up and speak into a microphone? We don't know what the questions are.
Oh, they can't hear you asking the questions. Did you hear that?
Okay.
Thank you, Doc.
While we're on the subject of drugs, year after year we often see these high-profile, multi-person drug busts. But it seems that many of these people are often back on the streets after a few months, and then back in court again after another couple months. Are these big drug busts effective, and how can we stop the cycle of drug crimes in this county?
I know that sometimes it seems like that, and I will tell you, when we are making drug raids, we are not only arresting big drug dealers, but also small-time drug dealers. Part of that strategy includes arresting confidential informants. This is how they remain effective. So I think that goes back to the previous question, that's why you may see somebody go back out on the street. I did a survey in my office, and I believe it was about 82% of the people that are arrested for delivering drugs go to state prison. So they're not back out on the streets. Now, I'm not talking about people that are picked up for a marijuana pipe or a small amount of marijuana, or even the ones that are possession for their own use. It might not be a small amount. But the major drug dealers, 82% of them go to state prison, and I think that's a pretty good sentence for them. Thank you.
I think the major drug sweeps have lost their shock and awe effect. I hear that a lot in Mount Carmel from people. Why are we spending resources grabbing people up, and then, like you said, Mr. Strasser, they're back out on the street? We need to go after the deliverers, the people who are selling these drugs, and hit them hard. I understand confidential informants and such, but you often see in the paper they grab somebody with a marijuana pipe and they throw them into the drug bust. So they are included in those drug busts. I've seen that in the news item myself with the photographs. The emphasis needs to be put on the people who are selling drugs as a business around here. And they need to get stiff sentences and harsh plea bargains, and they need to be taken to trial if they won't accept them.
All right, the next question will be asked by Matt Farron of the Milton Standard Journal.
There we go. Turn on. All right, thank you. This is for both the incumbent and the challenger. How would you define in your job circumstantial evidence, and how do you, or would you use it to obtain convictions?
How would I define circumstantial evidence?
Yes.
It's evidence.
Be specific, please.
Okay, it's evidence that's not directly linked to. It's not an eyewitness fact or a direct object that can be linked, or a fact in your case, any fact in your case that that tends to lead to the probable guilt of someone, but it isn't exactly conclusive. Successful cases can be made on circumstantial evidence. Sometimes the bigger cases are made on circumstantial evidence. They certainly aren't as easy as cases where you have a witness, or you have a confidential informant, or you have necessarily ironclad evidence. Those cases are easy. Circumstantial evidence cases are harder. Could I say I would do an entire case based solely on circumstantial evidence? I'd have to see the evidence.
So I would describe or define circumstantial evidence like this. If it looks like a duck, if it quacks like a duck, it's probably a duck. When the court defines circumstantial evidence to juries, they frequently give explanations like, if you go into a movie theater and the sun is out and it's shining, and then you come out after you watch the movie and there's water on all the cars and the sidewalks are wet and people are walking around with umbrellas, that's circumstantial evidence that it had rained. circumstantial evidence is sufficient to convict somebody. It is a harder case. I have gone to trial on only circumstantial evidence. It is a harder case to prove, but sometimes that's what the evidence that you have, and that's what you need to go forward in order to protect society. So we don't always have eyewitnesses, and I will tell you, when I was doing the sexual assault crimes, which is what I did for the bulk of my last 15 years in the DA's office, I did not have a lot of direct evidence. We never had eyewitnesses, except once it occurred in a convenience store, and the guy had taken the woman back to the office, and there was a camera in the office. It was the only time I ever had video evidence in a sexual assault crime. I was so excited about that. But we don't often have eyewitnesses in lots of crimes, so there is a lot of circumstantial evidence that has to be used, and it is solid evidence. In fact, the judge gives an instruction during a trial that you can convict on circumstantial evidence alone.
Okay, the next question. Jen.
Sorry about that.
I guess, yes, okay, it's on. It's obviously for both of you, but it stems from, and you were recently on WKOK with Mark Lawrence, and you were talking about the caseload in your office and the number of cases that each of your ADAs has to deal with in a given year. Can you talk a little bit about what do you see going forward? Because it's a huge caseload. How do you, as the current DA, expect to fix that, move that forward, get that issue sort of dealt with so that your DAs are not as swamped with work? And then Tony, if you were coming in as the DA, what would be the thing that you would do in the office to deal with that kind of caseload? Because it is, I believe, as you said, larger than what they deal with in the Philadelphia District Attorney's office.
Well, I did see all of the commissioner candidates here, and I would propose to them, we need more staff. I would point out, however, that when I took over office, we had a backload, I should say a caseload of approximately 900 cases. It's currently down to about 700 cases. Now, 700 sounds like a large number, but we have less than 300 that are pending trial at this point. The balance of the cases are either pending a guilty plea or they're scheduled for sentencing. We also have a program called ARD that there were changes to that started in January, and when those changes came into effect, it takes longer to get on ARD now. So we have been going after that caseload. And it's also a matter of being judicious with our resources. We need to make decisions based upon the evidence that we have, and though we'd like to take a lot more cases to trial, that doesn't necessarily always happen. Thank you.
I think when you're strapped for a budget, you have to be innovative and you have to do more with less. We ran into that in Mount Carmel many times. Mount Carmel Borough, our tax base is going down, yet we're expected to do more every year with the same amount of, or less tax dollars. I think efficiency is the key. I found that to be the key. Without boring everybody with too much legalese. I think plea bargains could be made quicker than they're made now. I think people could be scheduled for trial quicker. I'll tell you how. As soon as a charge is filed, if the district attorney's office were to get all the discovery, calculate a prior record score, offense gravity score, come up with a plea agreement, give it to the defense attorney at a preliminary hearing. If they don't want it, then you schedule them immediately for trial. You give them your discovery. They have 30 days to file an omnibus, and you put them on the trial list. And you work through your backload like that. Now, it's not going to be easy when you do that right away, because you're going to be dealing with what's coming in and what was behind you. But you got to face the music sooner or later. And in the sheriff's office, I walked into a couple hundred cases that were backlogged. I didn't like staying there until 9 o'clock at night, but now it's a breeze. Once you get through it and you set up a process and you're efficient about it, then you can manage the caseload. Obviously, you can't manage an infinite caseload, but you can, I think, manage a caseload pretty effectively.
This is a question from the audience. Would you prosecute a case involving medical marijuana where the treatment cured seizures in a child in the face of a medical necessity
Not sure what that last word is. Can you tell them? I think the gist of the question is there. So would you prosecute in a case where medical marijuana was needed for the seizures of a child?
The first question is, who says it's needed for the seizures of a child? The district attorney is a ministerial position. They're charged with prosecuting the laws of the Commonwealth. The legislature is in charge of saying what's legal and what isn't legal. Whether marijuana becomes legal here or not is ultimately up to the legislature. The laws that are in place were passed by the legislature, signed by the governor. However, you can have a common sense approach to it. But it's still illegal, and it would have to be prosecuted. You can't turn Northumberland County into a prosecution-free zone for medical marijuana, or everybody will be coming here and doing it. Unless you mean just specifically that one case with that one kid, but who said it was for the seizures? I mean, if it was a doctor in Pennsylvania who prescribed marijuana, they have a board that regulates them. It would have to, they would be subject to, I'm guessing, I'm not a doctor, but they have boards that regulate their prescriptions. But nonetheless, it's a crime in Pennsylvania, and if and until it's changed, it's a prosecutable offense. Should you throw a book at somebody for that? Common sense needs to come into play.
I don't know of any doctors in Pennsylvania that prescribe marijuana. I think that is illegal. So if someone is getting marijuana, they're obviously buying it off the street, and that would be one of the drug dealers that we were just talking about. And again, when my opponent talks about common sense, I would say that that is true. That's a crime that would be prosecuted. If there was an arrest made, the Commonwealth would prosecute that. However, that is a case where common sense needs to take over. That's a case we might very well do a plea agreement on, and it may be pled down to something, assuming that all the facts that were given in the question are true.
Could we maybe just continue and ask for each of you to address whether you think marijuana should be legalized?
I believe that marijuana is a gateway drug. I believe it leads to addictions and other matters. However, I do understand that there are studies that indicate that marijuana can have some medicinal purposes. And I think that if it comes down to marijuana being legalized for medicinal purposes, I don't know that I would object to that.
Again, as I stated before, that decision is best left to the legislature and the governor. The representatives and senators are elected by the people. They have the ability to go through hearings and have evidence presented to them on the medicinal value of marijuana. My job, or the job of the district attorney, of a prosecutor, is to prosecute the laws that are in effect by the legislature and signed by the governor. So that is completely up to the legislature and the governor.
But did you have an opinion? I mean, I think that question was for your opinion.
Well, medical marijuana, you say medical marijuana, or she answered medical marijuana?
That's what I thought the question was.
Was that the question about medical?
I believe the original question was about medical marijuana. I did just ask about legalizing marijuana, and maybe you both want to address it again, whether you gave your opinion or not. I wasn't necessarily holding you to that, but maybe we could address it from the standpoint of another topic that I think is probably on the minds of people here, and that's prison overcrowding. And we have a situation, obviously, in Northumberland County where we need to decide what's going to happen with the new prison. But so no, it was just related to marijuana, and I think it's a natural step to go then toward the issue with overcrowded prisons and the impact on the DA's office from that standpoint and that larger issue. Take that as you will as far as how you guys want to address that.
You mean how would that affect my prosecution of cases? That there's no prison, or that there's trouble with the prison?
Well, no. We just talked about caseload. We're talking about drug dealing and arrests for drugs and so forth. Obviously, some people are promoting the legalization of marijuana as, in part, maybe a way to address overcrowding in prisons and to
perhaps speed up the process of prosecution and the judicial process at large. So again, I was just feeding off the earlier discussion about medical marijuana to say whether marijuana should be legalized, and with that, if not, you know, is there any other way to address the overcrowding of the prisons and you know, from your perspective as a potential DA?
Well, I think there's already the ARD program, there's already treatment courts, drug court, behavioral court, and there's house arrest, there's intermediate punishments, there's a plethora of diversionary programs that don't put people in jail behind bars. The people that are in jail behind bars are people who need to be off the street, presumably. But there's many programs to keep people out of jail. There's a whole list of them. But
even if they are charged, there's ways to keep them out of jail.
Yes. But the DA's job isn't to throw, not prosecute somebody because the jail's overcrowded. I mean, you have to face a reality, but all that comes in after sentencing. You know, that comes in after a conviction. Your job as a DA is to prosecute crimes. If the prison's overcrowded, I mean, the prison's over. That the legislative branch, the commissioners and the legislators set the budgets, and they need to see that these people need to be in jail. The district attorney is, yes, on the prison board, but they don't have any say in the monies that are expended. That all comes from the commissioners. The district attorney's job is to prosecute crimes, and that's what I would do if I was district attorney. And if the prison was overcrowded, doesn't mean I would let someone go.
As my opponent indicated, the district attorney is by statute a member of the prison board, which means that the prison board oversees the running of the prison. Now, that's gotten a lot simpler since January. That's what we're overseeing. But when you're making decisions about sentences and that sort of things, yes, you have to be cognizant of the fact that we don't have a prison now. Our judges are very cognizant of that fact. We have been approached about giving people ARD that typically I might not offer ARD to, and also using the diversionary programs. Our judges are big supporters of the diversionary programs, which do save the taxpayers a lot of money in keeping us from having to incarcerate people. But overcrowding does not mean that we need to build more prisons. It means that we need to address the rehabilitation issues.
I guess while we're still on the subject of the prison, as a district attorney, you would obviously have a spot on the prison board. What is your opinion on where the current prison project is headed?
Well, the location of the prison, the cost to build it, all of those items, it has been made abundantly clear that that is an issue for the commissioners and not for the prison board. Although I think as district attorney, once they decide on a plan, I'm going to try and push to have more input, just even as a citizen, not necessarily as a prison board member. I believe the site here in Sunbury is a good site in that it is close to the courthouse. Transportation costs have gone through the roof in the last 9 months based upon having to go to Cole Township and get people to bring them to court. Although that site is not approved to be a residential site, it's going to need some cleanup. I'm understanding there may be some grant money available for that, but I think the site in Sunbury is appropriate.
Again, I'm going to go back to the district attorney sits on the prison board. The prison board is in charge of the managing of a prison. The county code's clear that commissioners are in charge of buildings and facilities. They're also in the best position to determine that because that's their job. I agree that the prison should be near the courthouse for transportation costs. But the construction of the prison and where it's at, I don't have anywhere near the amount of numbers I would need to make that decision had this be a building in Mount Carmel. I would need to know a whole lot more about it. I'd need all of the numbers, all of the reports in order to come up with any kind of intelligible decision. But I do know, working for the sheriff, that transporting prisoners is becoming an issue, being that they're housed all over the place, and that's certainly inefficient for the court. So I do think that it should be in Sunbury.
Thank you. For both the incumbent and the challenger, could you, as a prosecutor, name some legitimate excuses to be excused from jury duty? Please be specific. I was serious.
You could almost say anything, and as long as the judge asks you if it will sway your opinion one way or the other, if it would get in the way of you judging the facts, one of the parties would have to strike you. Almost anything you say, the judge will ask you. I mean, within reason, the judge will ask you, will that in any way hinder your, get in the way of you deciding the facts and the law? And if you say no, then he'll say, for the most part, okay, and then it'll be up to either the defense attorney or the district attorney to strike you. Now, I'm sure if you asked if, we give him the death penalty, can we flip the switch? I mean, you might get thrown off of the jury. But other than that, you're going to have to tell the judge that you cannot make a decision, but you're going to have to show up in court and get picked on the jury pool and have to tell the judge that.
None of the judges are here, right? When we're picking a jury, the process of jury selection is to find people that can be fair and impartial in a particular matter. To get excused before jury selection day, you need to have a good reason. It might be a prepaid vacation, it might be medical needs, that sort of things. When we go through jury selection on jury selection days, there are certain people that cannot sit and hear a child abuse case. And in fact, when we pick juries in child abuse cases, we have the most jurors excused because it's the type of case where people feel that they cannot put their emotions aside. They might have children or grandchildren of their own, or they might have a child that's the same age as a defendant. The standard is whether or not you can be fair and impartial in any particular matter. And so if you can't be fair and impartial, then you're going to be excused from jury duty. Is that general enough to help you out?
This is another question from our audience. Why do you feel we should elect you for DA in Northumberland County?
Well, I believe, as I've said, and you'll hear probably a dozen more times, that experience is important. The job of district attorney is not a job that should be a training ground for anyone. It's too important to our communities, the safety of our families, to be left as a place where somebody learns the job. I've been doing this for an extended period of time, and I believe those are my qualifications and experience to do the job. It's like anything else. You can't tie your shoe the first time that you try it when you're 6 years old, but keep doing it and you become more and more experienced and you can do the job of tying your shoes better. And it's sort of like that with the district attorney's office or any job. You learn how to do the job by being on the job. And it's too important for it to be your first job. Thank you.
I think I offer a fresh perspective, revamping of the office from head to toe. I have a track record in Mount Carmel of turning everything inside out, starting from the beginning. I've never put up with sloppiness or laziness or missed deadline. I've voted to fire people who have engaged in sloppiness and laziness and missed deadlines. I have dotted all my I's just about and crossed all my T's in the last 7 years in an elected office. I know how to manage a budget. I know how to manage personnel. I know how to set up policies and procedures. And I know how to look at things and wring all the slack out of a rope, so to speak, to get the biggest bang for your buck. And it's no secret that there's budget constraints, and the budget's been cut, and positions have been cut, and the caseloads have gone up, and you're asked to do more with less. I have experience doing just that. And I plan on taking the same amount of zeal and intensity that I put forth in Mount Carmel into the district attorney's office if I'm elected and given a chance to do that. Thank you.
Oh, let's see. Let's talk about Rule 600 because it's been in the news of late. From both of your perspectives, obviously it's in place. You said recently, Ann, that a lot of people try to use this rule because that would be great if I were sitting in jail and I could get out of jail. But that doesn't always come to fruition. When it does, obviously it makes news. Can you talk a little bit about some of, maybe use a specific example, how this does happen, and what are the circumstances around it? Because I'm sure, Tony, you have views as well about, when people are sitting in jail waiting trial. You've talked about efficiency. So I'm sure you see that as a breakdown of efficiency. Can you both address in whether or not you use the specific examples or in generalities, it makes people wonder what's going on when someone's walking the streets after sitting in jail because they haven't been prosecuted.
Absolutely, and that is a big issue. There's multiple people that were released on a dollar bail. And let me just explain what Rule 600 is, because there is two parts to it. Rule 600 is your right to a speedy trial. It's the codification of your constitutional right. It came from court cases, U.S. court cases, Pennsylvania court cases. And if you're not, obviously if you're not brought to trial within 180 days, you're released on a dollar. I think everyone knows that. If you're not brought to trial in 365 days, you could be released from your charges. 6 months is enough time, in my opinion, to bring anyone to trial. If you need more time than that, I don't know why they're charged. I don't see why that can't happen if you get ahead of everything and you have all your ducks in a row. Rule 600 also, it isn't just for a constitutional right of someone who is accused of a crime. It's also because a prosecutor's case does not get better with time. As one of my law professors said, unlike cheese and fine wine, a prosecutor's case does not get better with time. Witnesses forget. They die. They move. They become unavailable. A CI gets caught selling drugs again. It becomes discredible. Every day that goes by, that case gets a little weaker. Might be infinitesimally weaker, but yet it's weaker nonetheless. So it's not only is it a violation of the defendant's rights to be brought to trial in a speedy fashion, it's also a disservice to the community because your case gets weaker as time goes on.
I'm going to address particularly the Bob Snyder case, which is the case that has been all over the news. And let me tell you what happened with Bob Snyder's case. He is accused of attempted homicide in a shooting that occurred in his house. His wife was involved in that. She is the victim in this case. That happened in February of this year. He was scheduled to go to trial in May, July, August, and October. In each of those times, the defendant said, "We need more discovery." And while my opponent has characterized as, well, we can do this efficiently by providing it at the time of the preliminary hearing, that's just not possible in all cases. And in fact, in any case where we have any type of use of labs or expert reports, they are not available. The defendant in that case asked for a report for ballistics. I'm not sure why they need the ballistics report. I don't really see that as being an issue in the case as to whether or not a bullet came out of a particular gun. But they want ballistics reports. We don't have them. We still don't have them. State Police Lab, is that backed up? just like everybody else, and they're going under budget constraints. And when they are doing evidence and they are processing that evidence, they prosecute homicide cases first. And that's their rule of thumb. I don't have any control over it. So that defendant sought discovery. We received, and I think I said we didn't receive that discovery. We did receive that in the last 2 weeks. It was provided to the defendant in that case. And you know what? The defendant came and asked for continuance when that matter was scheduled for October, and the judge granted it. Now, I live with the judge's decision. I respect those decisions. That does not mean that I agree with them. So Rule 600 is not about a case getting worse with age. Some cases don't get worse with age. Some cases do. But it has nothing to do with whether or not a prosecutor's case gets worse with age. It has to do with a defendant's constitutional right.
Yes, and every case is not, you can't do every case, like I said before, when I said you can do it at the preliminary hearing. There are some cases, but the vast majority, I believe you can. And I believe the discussion about the prosecutor's case being worse with age comes from the Supreme Court opinion that initially set forward speedy trial rights.
I have next question, yes.
The question is primarily for you, Ann, but we want to have Tony weigh in, of course, on it too. I got to bring up the Colmont police joyriding firecracker case. And,
Of course you do.
Yeah, we've talked about it before many times. You've noted your close working relationship with police, and the reaction to that case and the fact that the police officer was charged with a summary offense, and you had made some comments to the fact that it didn't think it elevated to a crime that the DA really had to worry about. Some people interpreted that to be you giving preferential treatment to a police officer as in your position as DA. Explain to us why that case proceeded the way it did proceed, and whether you would do anything differently if you had to do it again. Tony, for as much as you know about the specifics of that, and maybe you could weigh in on how you would have handled it. But Ann, go ahead.
Well, I think when that case first came to me, first of all, I was not presented with all of the facts, which I found out later. Although I'm not sure that my decision would necessarily have changed. There were allegations that the defendant should have been charged in that case with fleeing and eluding. And fleeing and eluding is a case where somebody tries to outrun the police. The evidence...
And just for clarity then, so that would have been the misdemeanor charge, correct?
That would have been the misdemeanor charge. Now, again, I look at, when I'm evaluating a case, I look at the evidence. The evidence that was presented to me was that they were going 35 miles per hour. That road going up to, out of Coltman up to Marion Heights at some point turns into a 45 mile per hour zone. I would have to have proved to a jury beyond a reasonable doubt that they were fleeing and eluding the police. The testimony is that the defendant thought he knew, that the guys knew who he was, and that they were, that the police officer following him, knew who they were, and that they were turning around, the backseat passengers were turning around and waving at him. I don't believe that I could have proved beyond a reasonable doubt that there was fleeing and eluding. And so when I had indicated that I didn't think that it was a crime, and other people said, well, they were doing this and they were doing that, that was not the evidence that was presented to me. And I still believe that I would have been unable to prove beyond a reasonable doubt that he was guilty of fleeing and eluding.
Just before you go, Tony, if you don't mind. So who presented the evidence, and why do you think it wasn't fully presented to you that first time, or should have you asked more, or like what was the process that left that short of you getting a full understanding of what happened?
Okay, I was presented the evidence by a member of the Pennsylvania State Police at Milton. I was not given a written report. They came in and they talked to me. We have to file certain traffic offenses within 30 days. Otherwise, they can be thrown out. and it's not Rule 600, but it's another rule of procedure that say traffic offenses have to be filed within 30 days. So they were coming up on the 30 days. There was no written report. At the same time as that was happening, the state police were involved with the people up in the, and of course his name slips my mind, Frayne, up in Bloomingdale. And that police officer actually went up to, he ended up not filing the charges because he got called up there as a part of that detail when the police officer up there was shot and killed and the other officer was seriously injured. So it was kind of the perfect storm, so to speak, and that's why the evidence, I think, was presented to me as it was.
Andy, the evidence that I heard from the 911 tapes, I believe from Eric Chicatano had them on the news item website. They had the vehicle driving, yes, at a low rate of speed, but then it turned off into another municipality and it turned off into the bush, the wilderness. At that point, they're gone. And Judge Rosini, from what I understand, was quoted in your paper, I was in the courtroom, said that if, had you been a regular citizen, you would have been charged and probably a lot more severe. So he has his doubts, I would imagine, by that statement that I read in your paper. But that could have been avoided. You could always, the public needs to know that justice is done. When you have police officers or district attorneys and they're in charge of enforcing the law, and they're accused of possibly breaking the law, you can invoke the Commonwealth Attorneys Act, and you can ask that an assistant attorney general look into the matter, and they have their own agents that can come from, that don't know anyone here, that would give it the air, would wave away the air of impropriety. I mean, there doesn't have to be an actual conflict. A district attorney should also go through lengths to avoid even the appearance of any impropriety, so that an issue like this doesn't grow into an issue like this. So if I had to do that and it was a police officer who I know and work with, then I would have asked that the Attorney General investigate it and have an agent look in and come up with their own findings, and then at that point they have autonomy to prosecute and do as they see fit.
And I will just tell you that the Attorney General is not obligated to take any case, and the idea that they would take a case of this magnitude is probably improbable.
In the event that they would not take that case, the county code provides for the district attorney to appoint temporary prosecutors, special prosecutors, and temporary special detectives. I would then use money in my budget to appoint a special prosecutor, preferably from another county, and a special detective, in order to not make a simple incident like this grow into something that it has, and cast a shadow of doubt on the impartiality of the district attorney's office.
I'm not going to even respond again. Would you like me to respond? All right, then I will. First of all, you can no longer go to an adjacent county and ask somebody to prosecute a case. That procedure has been eliminated. It does not exist anymore. And again, based upon the magnitude of this case, I don't feel that I had a conflict with Mr. Stamens. I made a judgment call, and perhaps I should have called it different, but in the long run, I think I did make the right call, because I don't think it could have been proven.
If we could back up a little bit, is there a solution to speed up the process so potentially dangerous and violent offenders are not back out on the street?
I think it is.
Yeah, I think I went through, what I would do with the majority of the cases that I had if I was in charge of the office. I would get ahead of the ball. I would get on a dangerous case especially, I would make sure that I worked with the police officers so that I was comfortable that they had a case we could prove in court. And then after the arrest was made and I was comfortable I could prove something in court, I'd be ready to go to trial with it. They could take a plea bargain, which would be a stiff one, or they can go right on the trial list. And if they continue the case, if they ask for a continuance and the judge grants it, then that goes on them, not on the Commonwealth's time, so they are not released in 180 days. They can technically be in jail for way longer than 180 days, so long as so long as the defendant is causing the delay and not the Commonwealth. So efficiency would be the key to that not happening again. The proper number of Rule 600 petitions that are granted in a county, in my opinion, is 0.
And I guess, again, I'm just going to respond by saying that the number of, we did not agree, or I do not agree with the judge's calculation of Rule 600 in this case. But as I said, will live with that. We had
Which case?
the Bob Snyder case I was talking about, I'm sorry. We have very few people that get out on Rule 600. Our procedure is that we offer plea agreements at the preliminary hearings in the bulk of our cases. The cases that they are not offered is where we don't have sufficient information in order to do that. And we don't wait to arrest violent criminals until we have all the ballistic reports back.
Let's talk a little bit about the Adams case. That was a very high-profile case in the last couple of months. Huge drug bust in the city of Sunbury. Pictures all over the newspaper of drugs and money and cash and all sorts of things. And several months later, we have one of the defendants is walking out with a $50 fine. Did he have an amazing attorney? Was there a breakdown? What happened from your standpoint in that? And then, Tony, you're sitting a little bit on the outside looking in, but how would you address things like that as they come through? Did you feel like maybe there was a weakness in the case to begin with? So I'll give you an opportunity to respond after she does.
The Adams case arose when juvenile probation went into that home and discovered drugs in there. Can I still go? So juvenile probation went into the house and they found drugs all over the house. They found them in the attic, in the basement, and in the kitchen. They ended up searching the whole home. All the occupants of the home were arrested, as well as another individual that had been staying there off and on. The arrest ended up with a lot of drugs being taken off the street, and the suggestion that the police had taken in catnip is just a defense attorney's attempt to dismiss a case. Nobody took any catnip in that case. I am very proud of all the probation officers that were involved in that. The court ended up making a decision. We had attempted to proceed on a constructive possession position, saying that everybody in that house had control over those drugs. The court rejected that argument, although one of the defendants did admit to having a pipe, the pipe that was in the nightstand next to his bed, and the court gave him the fine. I do not agree with the judge's decision, but I think that arrest resulted in a lot of drugs being taken off the street, and by an excellent job being done by our probation officers and our police. They worked hard on that. My problem with the decision that was made is that the juvenile came in on that day. He was not represented by counsel. The Commonwealth objected to him testifying without having counsel. The court allowed that juvenile's constitutional right to counsel to be waived when there was no adult there that was interested in what was happening to him. There was nobody there representing his interests. So that juvenile came in and said, no, it wasn't my parents, it was all mine. I think that was a grave injustice that was done to that child. And the decision is made, we move on. I accept that decision. This was no publicity stunt. The drugs that were on that table were real. The money found in that house was real. We took that stuff off the street. I would have liked people to have jail time in that, in particular the adults there. That didn't happen. But again, I live with that decision.
Okay, and your question to me was what, my opinion on that whole issue?
Well, yes, looking at that from the outside, but also, she's talking about decisions that, this seemed to be the court's decision, that ultimately looks bad when you see it, splashed across the front of the paper. So what's your take on that? And, as DA, how would you deal with those kinds of things when, you think you've got a good case and for whatever reason the judge rules the way the judge rules?
Well, I don't think there's any problem with the case. I don't think the case would have gotten much attention had it just been an arrest of 3 people and 2 of the charges be dismissed at the magistrate's office. I mean, it would have been an issue, but I don't think it would have been a huge issue. I don't think it would have been a campaign issue. I think what made it an issue was the drugs and money spread across the table. It was the confiscation of motorcycles, vehicles, TVs, and cash that were supposedly in this drug operation. That were then and then the photograph and press release that were given to the media outlets that drummed this case up, only to find out later that the charges were dismissed. I don't think there's anything wrong with the arrest. You cast a wide net, and if the magistrate doesn't want to see it your way, if he dismisses it, they take a preliminary hearing, he dismisses it. Yeah, you could refile charges, but in reality, that doesn't happen often. I don't think the police did anything wrong, or probation, or the district attorney. I think what went wrong with that was the publicity and the pomp and circumstance that went in that, and the motorcycles being confiscated and everything else, and then having to be given back. There's an egg on your face if you put yourself out there as someone who took $50,000 worth of drugs and property off the street and then have to give a lot of it back. And I think there's still some question on, I believe, the radio or the newspaper, somehow the vehicles had to be given back, but yet there's still $50,000 worth of drugs. So I don't know which number was correct, the first number or the second number, because drugs plus motorcycles plus a car plus a TV can't equal $50,000. If that equals $50,000, then minus the cars, the drugs can't still be worth $50,000. The short answer is I don't think there's anything wrong with the arrest or how that went through. I don't think it would have been much more than a second-page story if it wasn't blown out of the press releases for an issue.
First of all, the Commonwealth did not issue a press release in that case. I was invited to come down by the probation officers. We did not issue a press release. That was the press that came and did that. And secondly, you could not refile charges. One of the defendants entered a guilty plea, so therefore I cannot refile the charges against that defendant.
That's true. I apologize for my oversight. One of them did, yes, that's true. What I'm talking about is, avoid the air of impropriety when there's an election a few weeks away and, the candidate's in front of a whole big table, and then it gets thrown out later. That's where the problem comes in. That's where the people really start to doubt whether your motivations. And I've never used my seat on council for any type of publicity. And I would certainly never do that as district attorney.
Hello, hello. Congratulations, Lee. All right, we have an audience question directed to Ann. Tony, you're more than welcome to weigh in after Ann answers it. You stated that there is a lot more administrative work involved than you had anticipated, and that you miss not spending as much time in the court. If this DA position is so different from what you had expected, how can you say that experience is the sole issue in this campaign if what you are doing is so different than what you had expected?
Well, what I'm doing, there is a lot more administrative work. And I spend hours, and if anybody looks, you'll see me at the courthouse mostly after hours, trying to do the administrative work because you are constantly being interrupted and asked questions. No offense to any of my assistants, I love them all, they're all very good workers, but I have an open door policy. My door stays open unless, of course, it's something confidential that I'm on the phone with. And they walk in, and I am constantly being asked my opinion. This is what's happening in a particular case. How do I handle this particular case? What should I do there? And that's what I guess I meant about a lot more administrative work. I have to go over the budget. But a lot of those things get done actually after hours when I'm there on my own. I don't get to go into court and do guilty pleas on a routine basis. I do miss that, although particularly over the summer when we had a lot of vacations, I was able to get to the courtroom more. So I guess that kind of would answer the question.
I have experience. Your question to me would be just to respond on that. I mean, I was curious of that myself. I mean, because obviously, we've heard a lot about experience in the campaign, a ton about experience, and I read the same articles as you said to me, where, and I wondered the same thing, where my opponent said that the administrative work, she never gave Tony Rosini credit because there's so much work here to be done that she never knew he did, and then she also said on, I believe it was in the radio or maybe one of the newspapers, she said that she doesn't get into court as much. One of her regrets, I think on the radio, one of her regrets is she doesn't get in court as much, and I wondered the same thing, how experience could, you know, if this job is so different from her last job, then how could that, how could her prior experience be the defining issue? I have experience in administrations. I have experience in, she said, budgets. I dealt with budgets inside out, upside down, every which way. I've dealt with employees. I've had 100 questions asked. We had a borough manager who pretty much wouldn't do anything without asking me. I got hundreds of calls, all different times a day. I'm used to that. I like that kind of excitement, and I like that kind of responsibility.
And if I could just add this, the administrative stuff, the budget takes up very little of my time. My ADAs are coming in and asking me legal questions, and you need to have the experience to be able to answer those legal questions.
All right. All right, thank you. I'm guessing this one's directed toward Tony first. Montour, this is from the audience. Montour County, I'm guessing here, sent someone across the U.S. to pick up someone who was out on bail. Now, I'm assuming that the cross-country travel was not part of their bail conditions. Would you as a DA do that, and what does it cost to do this? Asked an audience member.
Exact cost of what it costs to transport someone across the United States, whether it was done on plane or in vehicle? Does the audience member mention that?
They were not specific.
Okay. I would assume it was done by vehicle. Yes. The cost is tacked on to the person. I know we don't have we don't have the utmost success in getting blood from a stone from a criminal defendant, but the cost does go on to the defendant. And if somebody was wanted, and there was they had to face charges here, and there was a warrant out for them, and the sheriff asked to go get them. I know in this county, I know that the district attorney usually pays for the extradition out of their budget, I believe, for a long extradition like that, in a non-contiguous state. But yes, absolutely, I'd go pick somebody up in another state, and I would ask that they be brought here. Now, would I bring them here for, you know, failing to appear for, you know, a bench warrant in a speeding ticket or something? Then maybe not. But any kind of crime, yes, absolutely.
We actually have a process whereby we determine who we're going to extradite and who we're not going to extradite. When someone has a warrant out for them and it's from an adjacent state, so say New Jersey, New York, Delaware, Maryland, if it is, we will go and get them in all cases. If we would have somebody in California that was wanted on a misdemeanor offense, we will not necessarily go and get them because it's cost prohibitive. However, there are other avenues for us to use. The U.S. Marshals have assisted us on multiple occasions where they have transported an individual part way, and then we've been able to go and get them when they got closer. It's not as expeditious as we would like, but it does save dollars.
Thank you.
Let's go to the compare and contrast portion of our debate. What do you think you bring to the job of DA that your opponent does not? And let's see if we can come up with something other than experience, just because we've talked about it. I know that's not fair.
It is fair. That's my favorite word.
Okay, you can use that word, but if there's something else that you would like to bring to the fore,
Well,
both of you, that, let's compare and contrast.
I'm going to talk about my qualifications and also my background. I'm a lot of things. I've been called a lot of things in this life, but I'm a lot of things, including being a wife, a mother. I have a variety of a background. I grew up working since the time I was 13. My first job was picking asparagus. I waitressed, I bartended, I babysat. I never worked retail, but I have a variety of experiences which have opened me up to meeting a lot of different people and having a background and a feel on people. And in the legal field, I was a public defender for 2 years. I was the first custody master in Northumberland County, and all of that, I think, lends itself to my qualifications. I know people. I've been around. I understand the plight of victims, and I also understand where defendants come from. I think that my experience gives me the ability to make judgment calls in order to decide what is the appropriate disposition of a case.
And I bring about massive change. I also bring these, for those of you who know me in Mount Carmel, I bring the same amount of maniacal zeal to this job as I did there. I know a lot of you don't know me, but the people in Mount Carmel know that I have dug into every single aspect of the borough. I have dug into people who I believe have committed criminal acts, but unfortunately they haven't gone anywhere yet. And I bring that energy and a fresh look at everything. Every so often, things need to be revamped from beginning to end. And that's what I offer the most. I will look at every single process, and I will try to make it as efficient as possible so we can do more with the same amount of budget. I know I've said that before, but if I had to be contrasted in any way, I've already proven that I can manage dwindling resources. And I have a 7-year record. I have a voting record. Not that being on the borough council directly translates to district attorney, but it is indicative of my work ethic and our ingenuity. Since I got on council, we haven't raised taxes. We've paid off all of our debt. We don't even have a car payment. We have a balanced budget, and we're actually a creditor borough. We loan the Anthracite Fire Company $188,000. They owe us money. Now, I'm willing to bet, and by the way, I had no experience with borough council when I ran. Zero. None. I'd be willing to bet that there is no more than a handful of municipalities in the state of Pennsylvania that are creditor boroughs. I bring that same kind of ingenuity to the district attorney's office, and I'd apply that to not only the management of the office, but the tackling of the cases, the building the cases, the digging in the information, and going 100% all the way on every single thing we do.
And I would just add to that management skills are fine, but it's legal experience that's important when you're a district attorney, because you have to make decisions based upon your legal acumen, and if you don't have it, you can't make the proper decisions.
I think knowledge of the law could come from all different places, and there's no question she has more experience than me. I mean, she's older than me. But, not that you can tell. No, I'm saying, because people say I look too young to be an attorney, that's why I say that. I didn't mean that. No, I really did, I did.
I am proud of every wrinkle on this face.
I didn't say that to slight my opponent. I say that because when I knocked on doors in the primary, people asked me if I was old enough to be an attorney. I guess that's, any other time that would be a compliment. I mean, right now, I guess it isn't, but I do have experience. I mean, I have experience, not as much as hers, admittedly. I mean, I can't beat the numbers. But I definitely have the energy and I definitely have the knowledge. And I've worked as a district attorney for a little while. Anyway, thank you.
Friends now. I think they wanted to get this wrapped up soon, so maybe we can just, and a little bit of a lighter note, Andy just touched on some things, but maybe you can each tell us a little bit about what you guys like to do for fun and you know, anything interesting, a hobby or whatever that maybe you partake in.
Well, I would tell you that my family takes up a great bit of my time, and if anyone saw the 6-year-old running around here, I wouldn't call her a hobby, but she is one of my favorite things, as well as my children, one of whom is, sorry Ellen, but the other one who's bringing me another grandchild in March. I haven't had a lot of time for fun, actually, since last July, but what I do like to do in my spare time is I take a lot of classes or I participate at the Y Arts. I wouldn't say it's a lot of classes. I've been throwing pottery for just a couple months here. It's very good work to throw a piece of clay on a wheel and beat up on it a little bit. Good stress reliever. I also like to garden. And I'm active in my church. I work at the church picnic. And those are sorts of things that I do in my spare time, what little there is.
Someone did you make good
I think you made good pretzel stick.
Well, in my free time, Andy, I like to lift weights. I've just got back into running because I hurt my back a little while ago. I also am always reading and on the computer, mostly YouTube I've been into lately, mostly educational videos. I know I'm kind of a nerd. I watch a lot about space and black holes and sciencey things, but I really like it, and it's an education you can get on there. One thing leads you into another. And my favorite hobby, because I really can't call it a job, is both being on the Borough Council and on the Mount Carmel Municipal Authority. There's always some kind of action. Sadly, on the borough, we've kind of went through everything, but there's always something going on in town. Somewhere, some problem, something unexpected hazard pops up.